everybody. We really appreciate your joining us this afternoon. As I said before, I'm Lynn Heck-Shafrin. I'm an attorney in New York where I am Senior Vice President at Legal Momentum and Director of Legal Momentum's National Judicial Education Program, which is known for good reasons by an acronym, NJEP. For those of you who don't know Legal Momentum, it was founded in 1970. It is the nation's oldest legal advocacy organization dedicated to advancing the rights of women and girls. Legal Momentum established NJEP in 1980 to provide education for everyone in the judicial system about the ways gender bias can undermine fairness across the spectrum of criminal, civil, family, and juvenile law. And I have been NJEP's director for more than 30 years. In the file box on your screen, or it may be called materials, sometimes the names are different, you will find background and contact information for Legal Momentum, National Judicial Education Program, and me. So that's all I'm going to say about myself today in the interest of time. I do want to express my thanks to the National Council of Juvenile and Family Court Judges and to Zach Draper for hosting this, providing all our technical support, and to the Department of Justice Office on Violence Against Women, which funds both the Council and NJEP to enable us to do this work. So let's begin by looking at a question, which, okay, let's try this. Aha, okay, little technical glitch there. This is a question from a judge in Milwaukee, Jeff Kramer. If a partner is controlling, abusive, and violent in the kitchen, the living room, and in public, why would he stop the abuse at the bedroom door? Since the inception of NJEP, we have focused on various aspects of adult victim sexual assault cases. And we have extensive resources on these issues that you can find written up in the materials, in that materials box. Several years ago, we realized that while NJEP and other organizations concerned with sexual assault were constantly stressing that the vast majority of sexual assaults are committed by someone the victim knows, almost no one had dealt directly with sexual assault in the specific context of intimate partner relationships and how it intersects with domestic violence. And this question from Judge Kremers is essentially just encapsulates this issue, because it really shows us how essentially unacknowledged and invisible this issue has been. So our response was to create a web course. And on your screen, you will see the title of the web course and the URL. This web course, Intimate Partner Sexual Abuse, Adjudicating this Hidden Dimension of Domestic Violence Cases, is funded by the State Justice Institute and the Office on Violence Against Women. It is available free to everybody at the URL that's up on your screen. It has 13 modules that cover everything from statutory reform to cultural defenses, interactive elements like self-tests, resources, links to many other organizations' work. And as we go along, if you find that you have information, material that we should link to, that we should add to this web course, I hope that you will be in touch with us and send it to us, because we are constantly updating this document. So before we answer Jeff Kremer's question about that why, about the bedroom door, let's talk about some numbers. Recently, the Centers for Disease Control published the results of the 2010 National Intimate Partner and Sexual Violence Survey. And the three questions that are now on your screen ask you, according to this survey, what percentage of U.S. women have been raped by an intimate partner? What percentage of U.S. women have been subjected to sexual violence other than rape by an intimate partner? And what percentage of U.S. men have been subjected to sexual violence other than rape by an intimate partner. And sexual violence other than rape is described in this survey as sexual coercion, unwanted sexual contact, and non-contact unwanted sexual experiences. So take a moment. Zach's going to put up the poll, and let us have your answers. Okay.
Are you ready for the next one?
Let's go with the next one. And let's go to the third. Okay. So not surprisingly, we are seeing a very, very wide range of answers, from very low to almost 100% in some categories. This is a statement that is in the findings of the National Intimate Partner and Sexual Violence Survey. Nearly 1 in 10 women in the United States has been raped by an intimate partner in her lifetime. And on the next slide, these are the answers to all 3 of these questions, and you can figure out for yourself how close or far away you were from what came up in this survey. 9.4% of women have been raped by an intimate partner. Just under 17% of women have been subjected to sexual violence other than rape by an intimate partner, and 8% of men subjected to sexual violence other than rape by an intimate partner. So now that we've looked at the numbers and we see that we are talking about a great number of people who have been subjected to intimate partner sexual violence, whether rape or some other form of sexual violence, let's look at Judge Kremer's question again. And take a minute and write into that Q&A box or the answer box, whatever Zach puts up. I'm sure you all have lots of ideas about what the answer to this question is, and let's hear from some of you. Wait, no, just a second. Something has gone wrong. Okay. Friends, I am very sorry. That is not set up as a question and answer box. We did not have room for all the questions that we wanted to pose. So let me back up, and before we talk about the statutory issues, let me just sort of go over, comments that people have made that's in the research that people make when we talk about this in seminars, and that I'm sure you're all thinking about today. Nobody wants to talk about sexual abuse in any context, much less in terms of an intimate partner, because as soon as a woman charges a man with any type of sexual misconduct, she loses credibility. Another problem is there's so much misinformation about rape that the public believes, that the justice system believes, that the notion that real rape victims are attacked by strangers in the bushes and report immediately and so on, means that someone who was attacked by an intimate partner and waits to report is not going to be perceived as a quote-unquote real victim. But what I'd like to raise with you with particularity is the fact that until very recently, it's the law itself that has made us think that everything stops at the bedroom door, because it has made marital violence of a sexual nature invisible. So now let's go to this next question, this next slide. So we asked you the first state to eliminate the complete marital rape exemption did so in what year? Can you put that up, Zach? Okay, well, we've had answers from 1967 up to practically yesterday. So let's go to the next question before we answer any of these. The last state to eliminate the complete marital rape exemption did so in what year? Okay. And finally, the question that we want to ask you is, how many states that have eliminated the complete marital rape exemption still have special exceptions in their rape laws that condition marital rape in ways that rape by a stranger or a non-stranger to whom the victim is not married do not apply? Okay, somebody wrote a number and then wrote scary. I like that. Well, someone not only knew the first year, they knew the state. Somebody wrote Nebraska, and indeed it was Nebraska in 1976. And many of you wrote, years in the 2000s, but actually the last state to officially eliminate the complete marital rape exemption is North Carolina in 1998. I think it's very interesting that there is a 22-year spread, because if we think about something that is being copycatted all the time and a kind of law that's really sweeping through the country very quickly, I think right now I'm thinking about the strangulation laws, situations where in domestic violence law, choking, quote unquote, had been a misdemeanor. And then we have the recognition that choking is really strangulation, which is really attempted murder. And so many states have so quickly moved to make this a felony. And I know of several states which are working on that, even as we speak. But here we have a 22-year gap. And in fact, we have a much longer gap from the time that women in the United States first wanted to see the elimination of the marital rape exemption, because the history buffs on the line will be interested to know that this was an issue in 1848 at the very first Women's Rights Convention in Seneca Falls. These early women, the names that you all know, Susan B. Anthony, Elizabeth Cady Stanton, Lucretia Mott, they were concerned about marital rape. But over the years, as the women's movement turned its attention to getting the vote, because the thought was if women could vote, everything would be taken care of, that fell off the radar, and it didn't come back onto the radar until 1976. And then, as we see this long evolution of states coming on board, eliminating the complete marital rape exemption, but then we have the issue of how many states still have a partial exemption. And it's at least 9. South Carolina, for example, requires that the victim report in 30 days or less, or else there can't be a prosecution. In Virginia, lesser sanctions, therapy can be the total sanction. Just today, I got an article about Washington State that perhaps even as we speak, their legislature is voting to remove the special rules for third-degree rape, which said that if the parties were married and the offender did not use force, then it couldn't be prosecuted. So hopefully that will be eliminated. But I encourage all of you to take a look at your own state statutes and see whether not just the complete marital rape has been eliminated, but whether there are any of these special rules or that it relates to lesser degrees of the crime where in fact marital rape is not being treated as seriously as non-marital rape. So one question that we might ask is, what if someone is coming in for an order of protection, she's in a situation where there's domestic violence, she's looking to the court for redress, and she has enough information about physical violence that she really doesn't need to present the sexual violence aspect to the courts. And why does that matter? So it's really important to be aware of sexual violence because we need to understand it as an aspect of domestic violence, an assertion, and many people perceive it as the ultimate assertion of power and control. A factor for risk assessment of all kinds that we will talk about, lethality, custody, and so on. And then behaviors to be addressed in victim services for victims, in prevention education, in batterer intervention programs, and in sex offender treatment. Now, intimate partner sexual abuse or assault is a continuum of behaviors. We chose to use the term sexual abuse for the web course because we wanted to capture the fact that there are so many aspects of intimate partner sexual violence that could not be indicted, let's put it that way. If we have a situation where there is sabotage of somebody's reproductive health because their partner is poking holes in a condom, that may not be something for which you would get an indictment. It's not a sexual assault, although perhaps some clever person could construe it that way, but it is certainly a form of sexual abuse. So this is a series of slides that just goes through a variety of examples of both verbal and physical kinds of sexual abuse. Using degrading language, just constant barrage of degrading language around sexuality, accusations about infidelity, punishing the victim for attracting others, even to the extent of checking underwear for signs of sex. Reproductive health issues are a major problem. Coercing sex without protection against pregnancy or sexually transmitted infections, and coercing pregnancy. We see a lot of this particularly in the teen population. Then attacking the partner when she becomes pregnant or coercing an abortion. I think that a lot of people don't think about extortion as an aspect of sexual abuse. But in point of fact, we have cases where the victim reports that she's divorced from her husband or she has not been married to the father of her child, but there is a child support order in place. And the person who's been ordered to pay child support says, I won't give you the child support unless you give me sex. Or in one startling case that's reported in Walter Kesserdy's research, He reported on a woman who lived in a rural area. She was going into labor and dependent upon her husband for transportation to the hospital. She's in acute pain, and he refuses to drive her to the hospital until she has intercourse with him. And the quotation is, "I said, please, husband's name, take me to the hospital. I begged as another contraction stormed across my body. Not until we have a screw," he insisted. So all the many ways that sexual abuse can be perpetrated don't just come under the quick heading of sexual violence or the kinds of things that are captured in the BJS survey, for example. Pornography and trafficking. Certainly the issue of women being forced to observe or participate in or enact pornography is a very big issue in these cases. Trafficking has come up sometimes in the early literature on this. People would use the phrase forced prostitution. Recently, Sanctuary for Families, which is a very well-known domestic violence organization here in New York, they're finding that women are coming in with a domestic violence complaint of physical abuse, and as they come to have trust in their counselor, they are talking about trafficking and being trafficked. So obviously, in terms of sexual assault, this list is one that everybody would think of. Forcing vaginal, oral, or anal sex, painful sex, forcing sex in front of children, sex with or in front of others, sex with children, sex with animals. And I would say this about our web course. There are a lot of places in the web course where it says, caveat, the next case we discuss is particularly graphic and disturbing. Obviously, all of these cases of interpersonal violence are disturbing. And it's not that we're trying to trivialize one, but I know for myself, as I did this research, every now and then I would come across a case that really, took my breath away. When you find a man forcing his wife to have sexual contact with their 6-year-old son by holding an axe to her neck, you kind of stop a minute and you think, well, I've read a lot of these cases, but this is another level. So none of this list is hyperbole. This is really what is happening. Then we have the issue of battering in relation to sex. We have women reporting that they would try to fight their partners off. This is from a book called Wife Rape that some of you may know, by Raquel Kennedy Bergen. Sometimes I was able to fight him off, and I would fight like wild, and he wouldn't be able to get in, but usually he would succeed. He put me in the hospital a lot. He broke my nose and my jaw and cut my wrists. And then in the context of trying to make up after a violent incident, apologizing, quote unquote, after battering by coercing sex, as if this would make it all right. We came across a case that was brought under the Hague Convention on International Child Abduction, where a woman described a pattern of coercive control, such as the husband requiring that she sit silently and watch him eat, and controlling all the family finances. And then there's an incident where he orders her, quote unquote, to take her place in our bed. This sense of ownership, and this is the way you make up for a violent incident. If you have sex, everything else is fine. Now, who are the victims in these cases? Well, basically anybody can be a victim. Women of all races and economic backgrounds, teens. Obviously, we are very recently focusing on teen dating violence and recognizing that this is not behavior that suddenly starts when someone turns 21. Elders, there's a lot of training that goes on elder abuse, but not very much that attends to the issue of elder sexual abuse. And I can tell you that one of the areas that the National Judicial Education Program has focused on is elder sexual abuse. We have a module on that that is described in the materials, in the resources list that's in the materials box. These modules, and I'll mention some others, are created to be self-contained and readily adaptable by anyone to use in your own webinars, to use in your own in-person trainings. They have faculty manuals and PowerPoints and suggested commentary. They can be adapted to add your local law and practice. They include exercises and resources, and we hope that they will be useful to you. Same-sex couples, we just had a new study just released this week or last week from the CDC suggesting that intimate partner sexual abuse is perpetrated against those who identify as gay, lesbian, and bisexual at rates equal or higher to those rates for those who identify as heterosexual. And finally, children as the victims in these cases. I mentioned before this case of a man who forced his wife to have sexual contact with their 6-year-old. In one study of 115 women who were in a domestic violence shelter, all of whom said they had been raped by their male partners, 18% reported that children had witnessed at least one sexual assault, and just over 5% reported that the partner had involved the child in a forced sex act. This is a quotation from a researcher named Walter de Cassidy, whose name I mentioned before. Any woman is a possible object of violence. What differs is not the woman, but the man. If the man is sexually abusive, he will victimize any woman with whom he lives or has lived. I think this is really a very important observation because so often the response to domestic violence of any kind is, why doesn't she leave? As if she left, that would be the cure. The violence is only happening because it's the relationship between these two particular people. And there's a lack of recognition that if this partner is violent, that violence is going to continue in the next relationship. So now let's turn to a self-test question that is about a study from another domestic violence shelter. There have been a number of these studies looking at intimate partner sexual abuse among battered women who are seeking orders of protection or who are participating in partners groups in batterers intervention programs. And I'm going to use this one particular study from Houston as the example. So we have a few questions for you. This is a study of 148 Houston women. They were all seeking orders of protection, and the researchers sought information about intimate partner sexual abuse using behaviorally based questions. So in this study, what percentage of these women reported that they had been subjected to sexual as well as physical abuse? And then what percentage of those reporting intimate partner sexual abuse listed this in their protection order petitions? Zach, this is a question for you. Can everybody see the answers as they come up?
No, but we can allow them to if you want.
Okay, no, I was just curious about that. I realized that I didn't know myself. So as this is coming up, as you would imagine, there are 149 of us online together, and you can imagine that these numbers are very diverse. Say again? Oh, okay, certainly. Zach, Eliana says that she's just gotten something where people are asking if we would please show the answers as they come up. So if you could please make that visible. All right? So, okay. So now, let me tell you a little more about how this study was conducted because it's important. As I said, this is a diverse group of 148 women. The researchers used a conservative definition of sexual abuse, and they asked only behaviorally based questions. That means they didn't say, did your partner ever rape you? They didn't put that official label on it. And they said, in your relationship, did, using the name of their partner, did so-and-so make you have sexual intercourse against your will? Did so-and-so physically force you to have sex? Did your partner make you have oral sex against your will? Did your partner make you have anal sex against your will? Did your partner use an object on you in a sexual way? When you ask behaviorally based questions and you don't put an official label on it, you get a lot more information. Some of you may have noticed that recently the Bureau of Justice Statistics came out with a report on sexual violence and domestic violence. And then there was the national survey from the CDC that we talked about earlier. And the numbers are just staggeringly different. You know, one is showing a great fall off in crimes of violence against women, and the other is showing something, as I say, very different. And my colleague Claudia Bailiff and I had extended conversations with the researchers on both of those studies. And as we had suspected, it really goes to how you frame your questions. And if you are the Bureau of Justice Statistics and you're collecting data from the point of view of what could be a reported crime, and you put a label on it, you get one kind of an answer. And if you are the CDC and you ask behaviorally based questions, you get a different kind of answer. And this is true, by the way, with batterer intervention programs, which we'll get to. So here's what the group found, what the group reported. Of these 148 women, 68% reported sexual as well as physical violence, 15% attributed a sexually transmitted infection to the abuse, 20% had a rape-related pregnancy, high levels of post-traumatic stress disorder, much higher than among the women subjected to physical violence only, and 0% of these women had mentioned sexual abuse in their protection order petitions. So why do you think that none of these women mentioned this in their orders for protection? Anybody going to write anything into our little chat box in the Q&A? Oh, that's coming up in chat. Embarrassment, shame, yes. Multiple attendees are typing. This is, I mean, we're very glad to have you all, but it's hard for 150 people to answer at once, right? They didn't think it was rape. Yes, too embarrassing. Order of protection proceedings are in public. And someone just wrote, fear of not being believed. We actually have been told many times by victim advocates and prosecutors that even if a victim discloses to them that there is sexual as well as physical violence in the situation, they will tell her, don't mention the sexual violence, because your credibility is an issue enough if you're only alleging physical violence. But once sexual violence comes into the picture, your credibility is out the window if you bring it up. Now, this is a very serious issue because at the very beginning I asked, why does it matter if we have enough information about physical violence to get an OP? Why does it matter if we don't talk about the sexual violence? And I said there were a lot of reasons why. Victim services, intervention services with batterers, risk assessment. How can the court know how dangerous someone is if this information is not available? And so one of the issue is nobody asked about it. And it's important to think about the forms that you use in your various agencies, in your court system, in your interviews with victims. Are you asking about sexual abuse using behaviorally based questions? Now, it's not necessarily that if sexual abuse is listed on the court intake form that everybody's going to check it off when they should, but it's a cue that this is something that the courts consider a form of abuse that is recognized in the justice system. And this is maybe not something that's, the yes may not come right away, but for people who didn't know that marital rape was a crime or that intimate partner sexual violence is a crime, who wouldn't think to mention it, who wouldn't think that the court system cared about it, having that on the form can be a very important cue. So let's just talk about the barriers to reporting generally. And so many of you wrote in. The fear of the abuser, overwhelming trauma, shame, denial, credibility, ignorance of the law, as we've just talked about. Now, another area that we want to mention is religious constraints, because we know that so many women do turn to their faith communities for help when they are in a situation where there is interpersonal violence. And we also know that some of the faith communities are in the lead in trying to deal with these issues. But we also know that there are some faith communities which are not. They really take the attitude that man has an absolute right to his wife's body, and they pressure women who are being victimized to stay in these relationships. On the next screen, there's a quotation from a book called Wife Rape that some of you may know by Raquel Kennedy Bergen, who talks about being a Catholic, talking to her priest, his telling her that she should go back, and she says, you feel compelled to keep the marriage together, and yet his behavior has really, the word is dissolved here, but it was obviously meant to be something else. You have that responsibility because he raped you. The next screen is a quotation from research and materials about intimate violence against women, South Asian women in the United States. And she's talking about attitudes in the Islamic community. The Islamic religious community tends to condemn any woman who seeks legal protection from an abusive spouse. Her actions are considered disloyal to the husband and the family. Now, this came up in a case in New Jersey a couple of years ago, 2010, where a young woman was being quote-unquote punished. I'm not kidding. That was her husband's word for what he was doing. He felt that she was not a good homemaker, and he was punishing her. And he pinched her private areas, and ultimately he raped her. And she went into court for protection. And he went into court and said, no, I didn't commit any crime. I didn't do anything that was outside the mores of my religious values. And he brought his imam into court. The family court agreed that these actions were culturally acceptable and in tune with his religious beliefs, and this was overturned by the appellate division in New Jersey that held that you can believe anything you want, but this is a general intent crime, and the question is, what did you do? This is, what are the limitations of the cultural defense? The free exercise of religion does not exempt an individual from generally applicable laws of criminal liability. So these are issues for people in any religious community that need to be thought through and addressed. As we said before, some of the faith leaders that we've worked with have been just phenomenal and really in front of this issue, but some unfortunately not. And then, of course, this is a major issue for women in communities of color. This is a statement from Professor Sarah Buell. I'm sure her name is known to many of you. She herself is a survivor of life-threatening domestic violence, and she's talking about race and culture. The victim's decision may be very much impacted on the fact that she's worried about how the police will treat a man of color, more worried about that than she is about her safety. Victims of color report being forced to choose between gender and race in deciding whether to use the criminal justice system for relief. Most feel that their survival dictates, siding with race. Those of you who received the domestic violence report may recall that in the May issue, Candace Wood had an article, Women of Color, the Pressure Not to Report and Sisterhood, in which she talks extensively about the pressure on black women not to report a crime against them, a crime of violence by a black man, because they don't want to put another black man into the system. And this is really a serious problem that we have to address in terms of both the racial inequalities that are basically built into our current justice system, and then our community attitudes. Immigrants, many issues for immigrants. They, first of all, may not even know that intimate partner rape, marital rape, is a crime in the United States. Oh, sorry, I didn't advance the slide. And that's when you get into these situations where you have cultural defenses, where people come from a background where this is not considered a crime. Language barriers and problems with interpreters. I mentioned before that the National Judicial Education Program has modules on a number of aspects of sexual assault cases. One of them, which is described in the materials that are available to you, is about interpreters in sexual assault cases and how important it is to have an interpreter who is not a relative of the victim or the offender, hopefully not even from that person's community, that there won't be the tension that arises from not wanting to wash the community's dirty linen in public, or the difficulty that we have encountered with many interpreters who simply don't think that domestic violence and sexual violence is very important and literally try to persuade the victim not to go forward. The issues for immigrants are of many different kinds. Rape is a deportable crime, and the victim may be concerned that if she reports and her partner is deported, there'll be no economic support for her children and herself. Or she may be concerned that she will be deported. And I hope you are all familiar with the U visa, which provides that if a victim of violence is willing to report and cooperate with the authorities, that she can obtain her own immigration status, that she doesn't have to worry about being deported. Then issues for people who are concerned about sexual orientation and gender identity. Services based on a heterosexual conception of a relationship, concerns about homophobia. Again, this is another community not wanting to promote negative stereotypes, the fear of not being believed. These are, so many issues that are common to communities themselves in and of themselves, but that need to be addressed in particular ways because each of these communities has particular concerns. Then what happens if somebody does try to go and seek services? What we find is that sexual assault and domestic violence victim agencies, they often view themselves as serving very distinct populations. Shelters saying, well, we don't handle rape here. Rape crisis centers saying, well, we can't help you with a domestic violence case. We don't do safety planning. This is a study that was from 2005. I hope that the numbers are dated, but Raquel Bergen, whom I mentioned before, and Elizabeth Barnhill, whom many of you may know from Iowa Sexual Assault Coalition. The study of battered women's shelters in 2005. Only 31% of battered women's shelters and 49% of rape crisis centers provided training on marital rape, and only 55% of battered women's shelters and rape crisis centers asking about victims' experiences with intimate partner sexual abuse. So, going back to what we were talking about before, about the necessity to ask these questions. And, in this study, they talked about literally finding women who said, I went to this kind of an agency or that kind of an agency, and I was turned away because I was told that I didn't fit. And, of course, inadequacy in the justice system. And that leads to disbelief and all the kinds of issues that we have been talking about. Lack of training for law enforcement, prosecutors, judges, and court personnel, and the hostile environment victims do not want to disclose. So let's talk now a little bit about offenders. And here is another question for you based on a very interesting study that was done with a large Northeastern Batterers Intervention Program. Again, using behaviorally based questions, they had a whole list, and we're asking you, of this group, what percentage answered yes to any one of this whole list of questions about have you ever engaged in certain specific types of conduct that met the legal definition of rape or sexual assault? So because you all now, you can see these numbers coming up, and you see that we're, going from, I think there was someone who had 0, and I just saw 95%. So this, we're getting a very wide range of answers here as we have to the other questions. So let's go to the next question, which said, of the group that answered yes, I have done, at least one of the things on this list, how many of them, what percentage said yes to the question that literally put a label on it, have you ever sexually abused your partner? So once again, I'm seeing everything from 0 to 30% on this list. And let me just close this out. How do I go to the next slide? So there was, out of this 229 men, 53% said yes. They had done one of the things on this list, and I'm going to come to the list in a moment. These were questions about actions that met the legal definition of rape or sexual assault in the program state. And then, how many men said, I beg your pardon, what percentage answered yes to the question, have you ever sexually abused your partner? 8%. Now, what's particularly interesting about this study is not just the raw numbers. It's that the researchers had in hand, it's the paper and pencil test, and so they could see what had the individual checked off, and then what had he said at the bottom of the list to this question, have you ever sexually abused your partner? So what you would have is, you would have men who acknowledged that they had used physical force to compel their partner to have sex against her will, but they didn't check off yes to have you ever sexually abused your partner. They would say yes to forcing their partner to have sex with other people or animals or objects, and they wouldn't say yes to have you ever sexually abused your partner. So now, this obviously it makes it a big difference when you say something out loud or say yes to it on paper, and it may be that some of the people who didn't say yes to the final question knew very well that they had sexually abused their partner, and they just didn't want to say yes. But based on what we know about what comes out in sex offender treatment, many of these men probably, in truth, did not believe that what they were doing would be considered sexual abuse or against the law. In sex offender treatment, when they try to have offenders write a narrative about a consensual sexual experience, treatment providers will tell you that what they typically get back at the very beginning of treatment is basically a rape scenario. And it's inch by inch that there is movement forward to an understanding that this is not a consensual event. This is a sexual assault. So this is some more information from this study. 15% of the entire sample and 25% of the husband rapists said they frequently forced their partner to have sex after a fight, using sex as a way to repossess women after a confrontation or illogically to try to make things better. And we talked before about this notion of apologizing after a battering incident by coercing sex. And again, I remind you of this Hague Convention case where the husband tells his wife, "Take your place in our bed." This is just a quotation from Graham Barnes, someone who's been very involved in working in batterer intervention programs for many years and was helpful to us in creating the web course. And you'll see he says that it was not until he had heard from the women in the partner groups over and over again that he realized the extent of sexual abuse in these relationships. So someone before I noticed had an answer to something that was, about assumption of your female partner as property. So here's a slide on, perpetrators use sexual abuse to punish their partner. They feel a sense of entitlement to have sex with their property. The last line is a quotation that, as someone who works a lot with judges, I thought was something that had to be included, again from Raquel Bergen's book. "I remember one time my husband told the judge, 'That's my wife. You can't tell me what to do with her.'" The treatment programs for offenders are, of course, an area of great concern. We don't have a lot of evidence that these programs do a lot of good. Just yesterday I was reading an extensive analysis that's just been produced in Washington State at the behest of their legislature to see whether the kinds of programs that are certified in Washington are having an impact. But putting aside for a moment whether these various kinds of intervention programs work, when we were working on the web course, we were just trying to find out, are the batterer intervention programs even addressing intimate partner sexual abuse? And we called providers across the country who were working under different models. Excuse me. And what we found was that some address intimate partner sexual abuse pro forma. They say, "We know this is part of what's going on, and we talk about it." Others said, "Well, we only bring this up if someone brings it up himself or if it comes up in the partners program." And then we actually ran into programs where they said, "Well, we don't have to deal with sexual abuse in our programs because we don't handle stranger cases here." And these were people who were officially getting referrals from the courts. Pardon. So let's turn to victim impact. What is the biggest myth about marital rape? Anybody want to put some answers in here? Okay. Well, what we see over and over again is people saying, "Well, it's really not a big deal because she's used to having sex with him, and so they had a bad night." This attitude shows up in research with potential jurors in marital rape cases, and I'll just say a word about that at the end. This is a photograph, a frame grab, a screenshot from a DVD that some of you may know. It was produced by the Department of Justice Office of Victims of Crime. It's called Victim Impact, Listen and Learn. This is a young woman who was a victim of life-threatening domestic violence. Her husband threatened to have her killed. And this is what she says. He was sexually abusive, and I think of all of it, that was probably the most painful, still probably the hardest to get past. When you're in a relationship with somebody that you love and they use sex forcefully, it's devastating, it's demoralizing. So here's a woman who says that worse even than having her life threatened was the fact that her husband abused her sexually. Another aspect of this is physical injuries. We think about rape basically as a one-time incident, whether it's a stranger assault or a non-stranger assault. In these intimate partner cases, it is typically a repeated form of assault. There was a study published in 2000 by the National Institute of Justice. Over half of the women raped by an intimate partner said they were victimized repeatedly by that partner. Overall, an average of 4.5 rapes by the same partner, but some victims reporting being raped 20 times and more. And these repeated rapes have a lot of physical consequences, internal injuries, chronic pain, really resulting in lifelong physical sequelae. So, are we moving? Mm-hmm. Okay. I said that a critical reason for knowing whether there is sexual as well as physical violence is because it has so important a red flag for risk assessment. What we know from the research is that sexual assault that is co-perpetrated with physical abuse heightens the risk of escalating violence and lethality for the victim and her children, and it is essential to know whether there's sexual violence when there is an abusive relationship in order to undertake informed risk assessment and provide the appropriate services for the victims and intervene appropriately with the offenders. In your materials, there is an article that you can download that I wrote for Judicial several years ago. It's called Risk Assessment and Intimate Partner Abuse, the Hidden Dimension of Domestic Violence, and it goes into all of these aspects of risk assessment in more detail. Now, I'm sure that everyone who's on this webinar knows this, that separation is the most dangerous time, and that most of the worst physical and sexual violence and murder are perpetrated on or after separation. So when we think about domestic violence murders, we typically think, is he going to kill her? And we are going to use the term femicide because at the urging of Jackie Campbell and others, we want to use a term that makes clear that we are talking about the deliberate and specific murder of women. Now, in reality, it's not just an issue of whether the batterer is going to kill his victim. You see on this list there are 7 different types of possible lethality. The victim, child murder, third parties, killing the whole family, suicide by the victim or the abuser, or will the victim kill the abuser? So what we know from the research is that in the United States, on average, every day, more than 3 women are murdered by current or former husbands or boyfriends. And we have the research from Jacqueline Campbell of Johns Hopkins, a name I'm sure is known to many of you, documenting that sexual assault in an intimate partner relationship is a strong indicator of potential lethality. In an 11-city study of actual and attempted domestic violence femicides, 57% of these cases included intimate partner sexual assault. And Professor Campbell concluded, taking all risk factors into account, a batterer who subjects his partner to forced sex in addition to physical violence is twice as likely to kill her as a batterer who subjects his partner to physical violence only. And before, when we were talking about that Houston study where 68% of the women said that they were being subjected to sexual as well as physical abuse, and none of them had mentioned it in their request for an order of protection, the researchers noted that the women who were being both physically and sexually abused reported more of the risk factors for femicide, such as strangulation and threats to children, than did those subjected to physical abuse only. The next slide is some very interesting research by a man named David Adams, a psychologist who was a pioneer in the effort to intervene with batterers and change their behavior. And a few years ago, he decided that he wanted to understand those batterers who commit murder. And so he actually went into prisons and he conducted extensive interviews with 31 men who were incarcerated for wife murder. And as what you might call a control group, since obviously he couldn't speak to the dead women, he interviewed 20 wives who had survived an attempted femicide and 19 additional women who survived potentially fatal attacks by their partners. And he found this striking commonality among these women. As you see, as it says on the slide in the quotation from the book, the men insisted that they had never been sexually violent or even coercive toward their partners, but 3/4 of the women he interviewed said their abusers had raped them. So it's not just that sexual assault, sexual abuse in an intimate partner relationship creates risks for the woman who is being directly abused. It also has implications for children in the context of custody. This is from an article by Catherine Ford that was in Sexual Assault Report. The sexual abuse of a parent has been seriously neglected, despite its potentially severe traumatic impact on children and association with greater risk to the safety and well-being of children and adult victims. What researchers find is that when, we know that there's just a huge literature on the impact of domestic violence on children and how extremely negative it is, whether the child is a witness to this directly or simply living in a home where there's a great deal of violence and tension. But what's been found is that when there is sexual as well as physical abuse, for these children, there is more severe depression, anxiety, and behavior problems. And these children internalize distorted and unhealthy messages about gender and sexual consent. So intimate partner sexual abuse of a parent heightens the risks to the children. And this is an important thing to take into account because we also know that batterers are particularly likely to try to manipulate the court system into giving them custody in order to continue to control their partners. And we also know that many batterers are awarded custody or unsupervised visitation, and that often this has grave consequences. This is a quotation from Lundy Bancroft, a name I'm sure, again, that many of you know. The history of sexual assaults against the mother is linked to increased risk of sexual abuse of the children and increased physical danger. So let me tell you about one of these cases that ended very badly. This is a case from Maryland, and a lot has been written about it, and so maybe some of you are familiar with it. Amy Castillo is a Baltimore pediatrician. In 2008, she had a temporary order of protection against her increasingly erratic and violent husband. She was divorcing him and trying to get him mental health help. He told her that the worst thing he could do to her would be to kill their children and leave her alive to grieve. When she went into court to get the final order of protection, the defense attorney for her estranged husband brought out the fact that she had had sexual relations with her husband shortly before seeking the final order. The judge could not understand that this was not a moment of romantic reconciliation. And it didn't mean that she was no longer afraid of this man. She was terrified, and she would have done anything, acquiesced in anything, to get this man out of their house and safeguard her children. When someone acquiesces to save herself, to save her children, that's not consent. But the judge just couldn't see it. He gave the husband unsupervised visitation, and a few months later he drowned all the children in a hotel bathtub. So what are we going to do about all of this? First of all, let's consider the discussion we had at the very beginning of this webinar about state statutes. Everybody needs to be sure that their state statutes have absolutely eliminated in every possible respect the exceptions for marital rape. Some of them are kind of hidden, but if you're a state that has a limited time for reporting or lesser sanctions for a marital rapist, you need to be in there changing this. Then how do we shape public opinion? The National Judicial Education Program is very concerned about the language that the media use, that judges use, that we use ourselves to talk about consensual sex and sexual violence. And very often there is the use of the terms for consensual sex. He had sex with her. Well, no, he didn't. He raped her, right? I mean, in these family situations. We're about to post a whole new module. Some of you may have heard my colleague Claudia Bailiff present on this. Raped or seduced, how language helps shape our response to sexual violence. This is an important issue. It really can shape the way public opinion moves. And one of the things that we've provided to you in the materials today is a guide for the media on reporting on domestic violence written by a Nevada judge who was shot by an abuser and was so disgusted with the way the media reported this case that he decided that he would try to step in and give them some guidance. We have found that when Claudia does this presentation on language, that it really resonates with people, that all of us, for example, if you look at any of these studies, it will say women experience sexual abuse at a rate of, well, experience is a subjective term. Where is the agency in there? Where is the invisible perpetrator? Rapes don't occur. Somebody perpetrates them. So this will be shortly up on our website, and we hope that you will look for it. Then we talked before about victim services agencies, the problem of people who are not cross-trained, domestic violence shelters, domestic violence advocates not being prepared to handle sexual abuse issues, and people working in rape crisis centers not being prepared to work with, I beg your pardon, domestic violence victims. We certainly need cross-training. The question there at the second question, ensure that intake forms and risk assessment instruments used with domestic violence victims include behaviorally based questions about intimate partner sexual abuse. I'm sure that many of you are already familiar with the danger assessment instrument that was created by Professor Jacqueline Campbell, whom I mentioned before. That instrument has a question. Quote, did he ever force you to have sex when you did not wish to do so? So it's right up there for someone to think about, to realize, oh, this too is a part of the abuse. This too is going to give me a sense of how dangerous the abuser is. And as we were preparing the web course, we found, intake form after intake form in the courts, there was no question about sexual abuse, and forms that people were using in services agencies, in batterer intervention agencies, not really addressing this issue, not even cueing people about this issue. So that's something that we need to be mindful of. Now, I mentioned before a barrier to reporting as the inadequacies of the justice system. The lack of education for judges and court clerks, everybody in the system, is high. And the problem is that we have found repeatedly is that we know the need is great, but we think that maybe there's not a lot of understanding on the part of court systems about how much they need judicial education about sexual assault and the intersection of sexual assault and domestic violence. Recently, we learned about a program for brand new judges, and it was a program that was developed using our document, Judges Tell What I Wish I Had Known Before I Presided in an Adult Victim Sexual Assault Case. And that is in your materials today. You can download that. And afterward, these brand new judges came to the presenter and said, we really want to thank you because we came in believing all those stereotypes that rapists are strangers who jump from the bushes. And we thought real victims had terrible injuries. And we thought, we had no understanding of the psychological impact of rape. So it's great that our materials were so effective, and it's great that these judges were so responsive and that they acknowledged, the difference between what they had come in believing and what they left understanding. But the fact is that that's just one group of 14 judges in one state. Think about all the other new judges and sitting judges who are not educated about these issues, who don't understand how to look for the red flags in these cases. So, for example, if an assault takes place in the bedroom, if the victim coming in for an order of protection says, he dragged me in the bedroom and threw me on the bed. Well, what happened next? Why did he assault her in the bedroom as opposed to in the living room? Is that a red flag? Is there a way, obviously we're talking now about a situation where you're not in front of a jury, is there a way that this woman can be asked, what happened next? Did your partner, your husband, make you do something sexual that you didn't want to do? The way of asking, as I said before, the behaviorally based questions issue is so important. And even what I'll call understanding the behaviorally based answer, as was commented in the chat box, someone wrote about people don't like to label themselves as victims. No question about it. People don't like to label themselves as victims. They don't like to label themselves as victims of rape. They don't like to label their partners as rapists. And there's a custody case that's going on right now in Washington, D.C., where the mother is alleging that the child was conceived in an act of, quote unquote, a non-consensual sexual intercourse. And the judge is furious with her, and I use that term advisedly because she won't call it rape. And he says, in his opinion, that she must be a liar because she knows the difference between non-consensual and rape, and she won't use the term rape. So the way that victims are not just willing but able to talk about this kind of abuse is something that's very sensitive, and the information needs to be elicited and understood in that context. Oh, someone has a question here. What do you do when a victim feels very uncomfortable discussing sexual assault in court or refuses to talk about it? I think you can only do what you can do. Obviously, there are victims who are never going to discuss this with a counselor, or they may be willing to discuss it with a counselor and they're not willing to discuss it in court. I think depending on the situation, it may be a situation where you want to explain to the individual that in order for you to to get the judge, the person who's going to make a decision about the order of protection or custody, to appreciate how dangerous this situation is, the issue of sexual abuse as well as physical abuse needs to be on the table. But if this person is reluctant or unwilling or simply, just too deeply humiliated and embarrassed, that's as far as you can go. I'm thinking about a brief that I worked on several years ago in one of these Crawford cases. The name, that's the case that says you've got to be able to, confront your accuser. And we had affidavits from any number of women talking about the terror of confronting their abuser. And this one woman wrote in and she said that the court had made a custody award which required her to have contact with her husband and to be in the courtroom with him, from time to time because he was always going back into court. And that he was sexually abusive in ways that, she said, it's like 10 years later, I still can't talk about it. And when I see him, my knees knock. But she felt that, as horrible as it was, she had to make that known to the court. But it also tells us that, this is a very, very difficult thing to talk about. And even though we're having this conversation here today as if it can come out, we all need to be mindful and respectful of the fact that it's the kind of information that doesn't come out with one interview. Whether you're a counselor or a prosecutor, you need to develop trust with the individual with whom you're working, and you need to think about whether this person can talk about this in court and be able to walk out of that without being totally destroyed. And, as I said at the top, if you're going for an order of protection and you have enough for what you need on physical violence, you may decide for a whole host of reasons that you're not going to raise this other issue. But it's certainly something that we all need to be mindful for, and we need to discuss, and we need to try to think about how we create a court system where people feel that if they do disclose sexual abuse, they will be understood and treated with respect. This one last slide is about criminal cases, and I just wanted to say a word or two about that. There has been a lot of research looking at attitudes toward marital rape among the public, and looking at groups of people as mock jurors, how they would decide these kinds of cases. So voir dire in a sexual assault case is always a very difficult problem because the courts don't want to give enough time to really flush out the people who would not be fair in sitting on these cases. But one of the really serious issues that comes up with marital rape is that if you have people in the jury pool who literally do not believe that a husband can rape his wife, or don't believe that a woman has a right to say no, that is a very serious problem in trying to prosecute a case of this nature. There was a study in which respondents were asked to rank the severity of 140 crimes, and they ranked forcible rape of a former spouse below stealing $25. So if you have people on a jury who don't think that this is a very important kind of crime, whose attitude is, no big deal, why is this, case even been brought in court, that is not the kind of person who should be sitting on a jury. And, when I talk about people who, don't believe that something can happen or that something is totally unimportant, I'm reminded of a case that was brought at the very beginning of her career by a woman who headed our sex crimes unit in the Manhattan District Attorney's Office in New York for many years. And she said that in the very first case of child sexual abuse that she had, the jury ended up in a hung jury because there was one woman on the jury who refused to believe that an adult could have sexual interest in a child, and it had never occurred to her to voir dire on that question. So if you have a marital rape case and you don't think to voir dire on the question of whether there are people in that jury pool who do not think that a man could rape his wife or do not think that marital rape should be illegal, those are not people that you want to have sitting on those cases. So let's see. An overwhelming majority of victims prefer, this is something in the chat room, prefer to navigate the family court system rather than criminal court. Consequently, abusers who commit heinous sexual assaults escape justice. How do we reconcile this? I don't have a good answer to that, to put it mildly, because there's almost an implicit assumption in that question that the criminal courts are doing a better job on this. And what we know is that the attrition is staggering. Very few sexual assaults are reported. Of those that are reported, police fail to fail to take many of them to the prosecutors. Prosecutors fail to indict. Juries and judges fail to convict. So that the number of sex abuse, sex assault offenders who even come to court and then end up being convicted is minuscule. Now, that's not to say we should let it rest there, but I just don't want anybody to go away thinking that if you could get these cases into the criminal justice system, you would have a terrific result. But I do think that we can do a few kinds of things. For example, even in looking at how domestic violence kinds of cases are classified, misdemeanor after misdemeanor after misdemeanor. There are a couple of states which are trying to say, a couple of, 3 misdemeanor crimes in a row, the next one is a felony, no matter what the person did. Excuse me, I spoke at the top of our webinar about strangulation statutes. And so many of these cases involve multiple forms of physical and sexual violence, and they involve strangulation. So if strangulation is a felony and the sentence can be appropriate, you might be able to get the person off the street going in with the strangulation evidence, not so much talking, or at all maybe, not talking about the sexual violence. Again, this is Cassandra who wrote this question. I don't have, as I said, a really great answer there, but I am reminded, I mentioned to you the head of our sex crimes unit in New York and her case, her child sexual abuse case. And, so when we talk about this and you go on the air and you don't want to create a situation where no one is willing to report because they think they'll be treated so badly, but you want people to have a realistic understanding of what the system is. And she always talks about the fact that we have made such a tremendous effort to reform rape laws, to get rid of the corroboration requirement, to create a situation where victims cannot be asked about every sexual thought they've ever had in their lives, to have serious sentences for offenders. In New York State, we used to have lesser sentences for sexual assault than for minor crimes. So the effort that we've made to reform the statutes in the courts, we don't want to leave that for nothing. We really want to try to work that and make the court system and the justice system live up to what we've all been working for. Somebody had a question here about false reporting. Oh. And so let me just say that of course, there is this great idea out there that women cry rape all the time and that these are fraudulent cases. brought for advantage of some kind or other in a divorce case or whatever it might be. But there's very good research now on false reporting. And what we have from the best methodologically sound research is that it's 3% to a maximum of 10%. And if you look in that publication of ours, Judges Tell, we have some of that research cited too in there, and you can find it in there. Is there anything else that anybody else would want to ask? I see we have 5 minutes left. Okay. Well, so I'm